Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients in the Dallas and Fort Worth area with their employment law, family law, and other litigation needs. Today's video will discuss the meaning of a serious medical condition under the Family Medical Leave Act, or FMLA. The meaning of a serious medical condition is important to an FMLA leave request because that request must show that an employee is eligible for FMLA protected leave, and second, that the leave request actually qualifies itself for protection under the Act. And so part of the process of determining whether the leave request qualifies under FMLA is to determine whether the leave request is attached to a serious medical condition for the employee's spouse, a child of the employee, or a parent of the employee. In general practice, this does not come up with most FMLA leave requests because often employers will just see that the treating physician has signed off on the certification paperwork that the leave period is medically necessary, and they'll accept the doctor at their word and just approve the request. But some employers are more particular and do scrutinize the certification to determine whether or not a serious medical condition is attached to that request. And from a litigation standpoint, we sometimes see that employers will scrutinize that leave request to see if the employee was actually qualified for FMLA leave. And that can be particularly important in cases where the employee is claiming that the employee made a valid request for leave and the employer wrongfully denied it and violated their FMLA rights. So it is important to know what needs to go into a valid FMLA leave request to make sure first that your employer can approve your request and you can take the time off that you need. And second, if something goes wrong, that you have a valid request that you can stand behind and protect yourself and protect your rights against. So let's talk about what FMLA and its corresponding regulations mean when they say a serious medical condition. There is a very specific specific definition under FMLA. This is not something that your employer can just kind of make up or look at each request and decide for themselves whether they feel it's a serious medical condition. Under FMLA, the medical condition described in the FMLA request either is a serious medical condition under the statutory definition or the regulatory definition, or it's not. The employer doesn't have that leeway to decide for themselves. Now, of course, an employer could look at that and say it's not a serious medical condition, but will approve the leave anyway. That's their prerogative, but they can't look at something and say, the statute might say it's a serious medical condition, but I don't feel that way, so request denied. That's not okay. That's going to lead to a violation of FMLA rights every time. So let's talk about what that actual definition is. There's basically two components to the definition. It's easier to think of it this way because we're going to break it out into one simple component and one more complicated component. So let's start off talking about that simple component. First, the serious medical condition must be an illness, impairment, physical, or mental condition. So this makes sense that if it's a medical condition, it has to be something related to the body, whether it's a physical or mental type of a condition. So from there, we've got that first, this is fairly straightforward component. When we get into the second component, these are a set of 5 qualifiers on that physical or mental condition that's going to clarify what actually takes it from a medical condition to a serious medical condition under FMLA. So again, there are 5 of these, and we'll run through them and talk about each one briefly. So first, we have a period of incapacity or treatment with inpatient care that is at least one overnight stay. So within this first qualifier, we've got kind of two components to itself. First is that there's some sort of incapacity. And when we say incapacity, we're talking about incapacity to perform your job. That there's an incapacity or treatment within an inpatient care setting. That's our first part. And second part, that period must include at least one overnight stay. And this is a very specific requirement that there's one overnight stay or more period of time. And there are cases where courts have specifically looked at the period of time where the employee was in some sort of inpatient care facility like a hospital or an ER room. And if the employee does not stay overnight, then even if the employee is there for a long period of time or shows up at 3 a.m., it's not enough unless the court can assess that there was one complete overnight stay within that facility or some inpatient facility. That's not going to count as staying at home, but actually some sort of treatment place like a hospital or a residential medical care facility. So that's one. Second, we have an incapacity that requires an absence of more than 3 days with continuing treatment. And so here we're going to look at that you are unable to go to work or to do your job in any other way for more than 3 continuous days in which you are under the continual care of some treating physician. What this means is you've got to have some sort of physician or some sort of healthcare expert who is providing you a treatment plan, something specific that you need to do. There's a lot of case law that deals with what exactly this kind of treatment is. If your doctor says, hey, you've got a cold, go home, take some Robitussin and take a nap, that's probably not going to be continuing treatment under the statute. But if your doctor tells you to go home, rest, drink plenty of fluids, take vitamin C, and here's a script for some medicine, that doctor has given you a specific treatment plan, and that could be enough, depending upon the medical condition, to qualify for continual treatment. But again, that's got to be for more than 3 days. If you go to the doctor for 2 days, or you go to the doctor and you're out for 2 days, that's not going to be enough to qualify for FMLA. So that's 2. Third, this one's pretty easy. Incapacity due to pregnancy or prenatal care. So pretty straightforward. You just had a baby and you're incapacitated due to just the physical effects of childbirth, or because you need to be available to provide continual care to your newborn child. That's definitely going to fall into FMLA protections as a serious medical condition. And of course, just to clarify there, if you're providing care to your newborn child, that's not a serious medical condition for you so much as it is a medical condition for the child that is causing an incapacity for you to perform your job, because you've got to be there to feed and change diapers and, maybe give medicine, whatever is going on with your newborn that makes it impossible for you to leave the home. That's that incapacity. But that's 3. Number 4 is an incapacity or treatment time for a chronic serious health condition, whether or not that condition is treatable. And that can be a little confusing, I suppose, because you get that description at the end of whether or not the condition is treatable. And what this means is you've either got time that you're not able to perform your job, either because of the effects of the health condition, because you're receiving treatment, or the effects of the treatment of that health condition. You've got all of that put together. That is the serious medical condition What FMLA says when it tags on at the end whether or not that condition is treatable is to point out that if you have a treatable condition, you're going to be covered. If you're getting treatment for that condition, you're covered. If your condition is not treatable, but still causes you an incapacity, or you get some sort of treatment to manage some of the symptoms, any of that is going to be covered as well. So we're not going to make employees choose between getting treatment for a health condition or not getting treatment, and we're not going to penalize them for having a health condition that's more serious or more of a chronic condition than others. If you fall anywhere within that, you're going to be fine. You've got a serious medical condition under FMLA. And then last, this one's a little confusing, that we have absences to receive multiple treatments that would lead to an incapacity of more than 3 days without that treatment. And there's kind of several components here, so let's work through an example on this one. Let's say that you're in a car accident where you're fairly seriously injured. Maybe you've got some broken legs. And due to that, you're not able to go to work and do your normal job because you've got to be on your feet a lot. So you could sit at home in a cast or whatever, incapacitated from doing your job. We could look at that and say, okay, we understand you're under continuing treatment, or you've had to stay in the hospital for more than 1 day. So we've got that serious medical condition otherwise, but maybe you were in the hospital for a few days, and then the doctor releases you from the hospital but says, hey, but you need to go to physical therapy so we can get you walking again, and you've got to go every day or every 2 days or whatever. In that situation, you've got time off to receive multiple treatments. Without that treatment, you're going to continue to be incapacitated from doing your job because you're not able to walk and stand up and all that good stuff. And so that would lead to an incapacity for more than 3 days without that treatment. So again, this is a situation where FMLA says we're not going to make an employee choose between protecting their job by not getting treatment or protecting their job by getting treatment. We want them to do whatever is best for their health. And so we're going to protect that employee who has been in a car accident by saying, go get those multiple treatments so that you can get better and come to work, for that situation that without the treatment would result in an incapacity and absence from work anyway. So to sort of circle that all back together, and maybe explain it a different way, try to make sense of it for as many people as I can. If you have a medical condition that would lead to an incapacity for more than 3 days without treatment, or car accident, cancer, various other kinds of chronic health conditions, but you could go get a series of treatments to cure or attempt to cure that condition, we're going to protect those absences to receive treatment within that serious medical condition so that we can entice you to go get the treatments and protect your job along the way. And the last thing I'll point out with this fifth qualifier is just to distinguish it briefly from the fourth one, where we talked about an incapacity or treatment of a chronic serious health condition, whether or not it's treatable. The difference in this fifth qualifier is that we don't care whether the medical or the health condition is chronic. It could be something short term, like a broken limb, where you're going to get physical therapy and stay in a cast or a sling or something, and then within weeks or maybe months, you're going to be back to normal after you get that treatment. It doesn't have to be something that you're going to live with for the rest of your life or some long period of time. So that as a whole is is our definition of a serious medical condition under FMLA. Remember, we've got those two components. Number one, the illness, impairment, physical or mental condition. And then second, we've got to hit at least one of those 5 qualifiers. If you have both components, then you're going to meet the serious medical condition element for a valid FMLA leave request. And then you've just got to make sure that you fit all the other elements of a valid request. And if you do, then your employer must approve that FMLA leave request. There are, of course, a number of other elements. I've talked about all of them together briefly in another video. There's certainly other information on my blog, on my website, that talks through not only more about serious medical conditions, but all the other elements that go into an FMLA leave request. We won't go into those for these videos because this has gone on long enough, and it'll be a good opportunity to break out and discuss those separately. So we'll hold off on that as far as those other elements are concerned and deal with them at another time. I hope you found this information useful. I hope it helped understand how FMLA treats medical conditions for protected leave, so that when you go to your doctor and ask them to complete a certification form that your employer needs for your FMLA request, you can make sure that your doctor is talking to the illness, impairment, physical or mental condition, as well as at least one of those qualifiers, so that when you take it to your employer, they can look at that and say, okay, there's a serious medical condition. So again, I hope the information was helpful. I appreciate your time, as always, listening to the video. If you've got comments, if you think the sound quality is terrible or whatever, feel free to leave those below. Otherwise, I encourage you to go look for other information on my website or the other videos on YouTube for more information. And as always, I'll see you next video. Thanks.